This program is not intended to replace professional legal advice or representation. If you have a legal concern, you are strongly encouraged to seek the advice of an attorney.
Hello everyone, I'm Yanique Otto, attorney at law in South Florida with the Otto Law Group. Thanks for joining us for this episode of Now You Know the Law. So you were served with a lawsuit and it came with a whole bunch of paperwork. You're not exactly sure what to do and you start asking around for some help. Despite being served with the paperwork and the summons which clearly states that you have 20 days to respond, life is busy and one thing leads to another and somehow you end up not responding to the lawsuit within the required time frame. The next thing you know, you get something in the mail saying that a default has been entered against you. And you're thinking, what in the world does that even mean? And moreover, what can I do about it? Well, here's what you need to know. In Florida, whenever you are served with a lawsuit, you have 20 days to respond. You can respond by filing an answer in which you admit or deny each allegation of the lawsuit. In addition to filing your answer, you may also file a counter petition in which you make your own allegations to which the other side must now respond within 10 days of being served. But if you fail to respond to the petition within the 20 days you are allotted, the other side has a right by law to get a default entered. In other words, they get to win the case by default because you did not timely respond. If this has happened to you, you might consider filing a motion to set aside the default as quickly as possible. Then ask the judge for a hearing to explain why the default should be in essence undone so that you will have a chance to present your case. But getting a default set aside is not that simple. The court will not just do it because they feel sorry for you. First, you must show that there was some excusable neglect, which has been described as the failure to perform a required act, usually procedural in nature, because of unusual circumstances. Second, you must show that you have a meritorious defense. In other words, you must show the judge that if you were given a chance to put on your case, you might actually win. And thirdly and finally, you must show due diligence in seeking relief from the default. So if you found out about the default in January and it took you several weeks or months to file this motion to set aside, chances are the judge will not grant your motion to set aside the default. Here's the bottom line. If a default judgment has been entered against you in a lawsuit, you must act quickly and with precision in order to preserve your legal rights. If you're in this position and need legal assistance, give our office a call and we can help you. Thanks for joining us and we'll see you next time. I'm Yanique Otto and Now You Know the Law.
Now You Know the Law is brought to you by the Otto Law Group. If you have a legal question, give us a call. We'll either help you with the matter or put you in touch with someone who can. To have your questions answered in one of our episodes, you may submit them via our Facebook page at facebook.com/Otto Law Group. The Otto Law Group, providing legal solutions.